Estates and future interests is the first big topic in any outline of real property, and that's how we're going to approach it also. Present possessory estates. There are 6 of them, and the best way to approach this material is not to consider them in a vacuum. The best way to consider present possessory estates is to recognize their place on a timeline. A present possessory estate typically is followed by a future interest. And the best way to approach future interests is by going chronologically. Future interests don't all apply to the various present possessory interests. And the best way to organize this material in your head, and the best way to understand it, is to see how the future interests are connected to present possessory interests. So, in this first video, we're going to go through each of the 6 present possessory estates. And as we do so, we're going to see how each one of these estates is connected to certain future interests. I say each one of these present possessory estates. What I really mean is all of them except one. So, as we go into the material about present possessory estates, mindful of the fact that we will be thinking ahead and looking at the future interests that attach, the first of the present possessory estates is the most powerful and the most important, a fee simple absolute. A fee simple absolute owner claims total possession to the property, and what makes a fee simple absolute is the fact that there is no future interest. If you've got a fee simple absolute, you own it, and you don't have to worry about any competition or any third party claiming a future interest to the land. So, a fee simple ownership interest is very simple. It isn't connected to a future interest, and the owner has got every right of ownership to that property, undiluted by any concerns about a future interest. So, that leaves us with only 5 present possessory estates to consider. Let's do it. First, we consider a fee simple determinable. A fee simple determinable. This is a present possessory estate that is connected to a future interest, and the future interest that a fee simple determinable is connected to is a possibility of reverter. The way to diagnose that a person is holding a fee simple determinable is by looking for language that reads so long as, until, or during, language like that. What happens with regard to a fee simple determinable is if the specific event spoken of occurs, the person who holds the fee simple determinable automatically loses his or her interest, and the future interest matures. The grantor automatically gets the property back in fee simple absolute. So we're now 1/3 of our way through the present possessory estates. We've looked at a fee simple absolute. We see that it's total ownership, not connected to a future interest. Next, we've seen a fee simple determinable. Here, the grantor claims a potential future interest that will mature automatically if the specified event occurs. Third, we have a fee simple subject to a condition subsequent. And here, the only future interest that applies is mentioned right in the name of the present possessory estate. A fee simple subject to a condition subsequent is strikingly similar to a fee simple determinable. But there's one big difference. With a fee simple determinable, the holder's interest terminates automatically in the event of the specified event in the grant. But with a fee simple subject to a condition subsequent, should that condition subsequent occur, the grantor has a right of re-entry. But that right of re-entry must be actively asserted by the original grantor. And if the grantor doesn't assert that right of re-entry, he or she can be said to have waived it. So, the big difference between a fee simple determinable and a fee simple subject to a condition subsequent is the timing. A fee simple determinable can trigger a future interest automatically, whereas a fee simple subject to a condition subsequent cannot. A fee simple subject to a condition subsequent triggers the grantor's right to re-entry. It does not automatically terminate the holder's interest as does a fee simple determinable. Now, we turn to our fourth present possessory estate, and that is a fee simple subject to an executory interest. The difference between this future interest, a fee simple subject to an executory interest, and the earlier couple that we just looked at, a fee simple determinable or a fee simple subject to a condition subsequent, is this. With regard to a fee simple subject to an executory interest, that future interest is held not by the grantor, but by some third party. So already we begin to see that the law of estates and future interests is really quite well organized itself. And once we understand the organization of this material, spotting the issues becomes much, much easier. We've already been able to distinguish a fee simple determinable from a fee simple subject to a condition subsequent in one clear black and white way. A fee simple determinable automatically terminates, whereas a fee simple subject to a condition subsequent does not automatically terminate, but instead triggers a right of re-entry in the grantor. Next, we have turned to a fee simple subject to an executory interest. Again, superficially, this looks strikingly similar to a fee simple determinable or a fee simple subject to a condition subsequent. But there's one big difference. The future interest holder of an executory interest is a third party, somebody other than the grantor or grantee. Now, the executory interest, future interest, has one additional complication. There can be either shifting or springing executory interest. A shifting executory interest takes that future interest and vests it in the third party automatically, whereas a springing executory interest also acts automatically, but technically what's going on is the holder's right goes first back to the grantor and then springs to the third party. But the basics of a fee simple subject to an executory interest are quite simple. The holder of that future interest is a third party, not the grantor. And that wraps up the hardest part of this material. It's taken us a little less than 8 minutes to cover it. And I counsel you here, as I have across the board, go forth and practice. You'll see that the material that I have just presented is just about all you need to know to make sense out of a majority of the questions. Obviously, there's plenty more stuff that you need to know, but the best way to learn it is to tuck it into your outline through practice, as opposed to doing a lot of upfront studying and then practicing this material at the last minute. We've got 2 more present possessory estates to consider. We've already considered a fee simple absolute, a fee simple determinable, a fee simple subject to a condition subsequent, and a fee simple subject to an executory interest. Next, we consider life estates. A life estate is a present possessory interest in land, but it is time sensitive or time limited. We see that there are technically a couple of different types of life estates. There's a life estate that is measured based on the life of the grantor, and a life estate that is based on the life of some other identifiable person. Life estates are connected either to a reversion to the grantor or a remainder to a third party. So life estates are connected to a couple of different possible future interests. But it's easy to diagnose these future interests based on whether they are held by the grantor, in which case there would be a reversion, or if the future interest is held by a third party, in which case it's a remainder. Again, this material is surprisingly straightforward, surprisingly intuitively sensible, and surprisingly uncomplicated if you choose to look at it in the way that I am suggesting. And we're going to consider future interests again for a few minutes in the next video in order. So Now, as we pause to consider issues relating to life estates, we see that the first thing that we care about is how long is the estate, which life will serve to measure it. But also we see that there are discussions often required on essays and straight questions on the MBE with regard to the rights of the parties to the land both during and after the life estate. And probably the most common issue that arises here is the issue of waste. Waste is an issue that we've considered in the law of torts. Waste is where some damage is done to the property. And we see there are a couple of different types of waste. There's affirmative waste, where the holder of the life tenancy deliberately damages the property. Well, he or she will be liable for that damage to the future interest holder. Also, we see permissive waste. This is where the life estate holder has failed properly to maintain or keep up the property. So, deferred maintenance is a type of waste called permissive waste. Again, the life estate holder is liable. Then, the most interesting and complicated type of waste is ameliorative waste. This is where the life tenant has attempted at least to improve the property. But remember that the grantor typically is entitled to get the land back in the same condition it was at the time of the grant. So ameliorative waste, which may be said to improve the property, is still waste. And the most important idea for our purposes here in real property is that any remainderman, including a contingent remainderman, has the authority and has standing to come to court to enjoin waste. So we already see here in real property that plaintiffs will be seeking equity powers from the court. Remember, land is unique. Every parcel of land is unique, and therefore the equity powers of the court are a lot closer to the surface here in real property than they are typically in contracts or torts. We also have seen questions, both on the multi-state and on essays, where a prospective life tenant chooses to renounce that interest or to reject the life estate. And what that act does, where a life tenant rejects the estate, what it does is it accelerates the future interest. One final detail with regard to life estates. Suppose we've got a parcel of property which is subject to a mortgage at the time that the life estate is created. Under those circumstances, the tenant is liable to pay the interest on the mortgage and to pay the taxes on the property, and the remainderman is responsible for paying the principal. And that leaves us with only one present possessory estate to consider, and that is a fee tail. We've saved the easiest for last. A fee tail is a grant to A and to A's heirs. In most jurisdictions, this will merge and it will result in a fee simple absolute to the grantee. And that wraps up about as quick a consideration of the present possessory estates as you're likely to see. And the service that I have done you here is not only to spell it out fairly concisely, but most importantly of all, to show you that the present possessory estates are connected to the future interests. And the best way to understand the future interests is to see exactly what those connections are.